Good morning, ladies and gentlemen. Yeah, can you just give me an indication that you can hear me and see me?
Morning, Julia. Yes, we can hear you and we can see your beautiful face.
Thank you so much. Thank you, Mr. Hart and Percy.
It's fine.
Thank you. Thank you so much. Good morning, ladies and gentlemen. I would like to extend a warm welcome to principal officers, trustees, administrators, and all stakeholders within the retirement funds industry. Thank you for taking time to participate in this webinar on contributions in terms of Section 13A of the Pension Funds Act. I'd like to thank our speakers, obviously, for taking time to participate in this valuable initiative. We look forward to hearing your presentations. My name is Julia Masike. I'm an analyst in the Retirement Funds Conduct Supervision Department at the Financial Sector Conduct Authority, FSCA, and I'll be your facilitator for the webinar today. Just a few house rules before we start the official program. This webinar will be recorded. You are welcome to post questions and comments on the chat function or make use of the raise hand function, in which case the production team will unmute you. The speakers will, time permitting of course, answer questions at the end of their respective presentations, and depending on their availability, they will also take questions in the Q&A session. The presentations will be made available on the FSCA website, and the recording will be made available on the FSCA South Africa YouTube page. We kindly request that you complete the feedback survey that will be made available or shared with you later. We appreciate your feedback from the last webinar, and we promise we'll incorporate some of your suggestions in our future engagements. For an example, it was suggested that we have webinars that are focused specific. So we focus on a specific area, and it was also suggested that the webinars are too long and we maybe look at shortening the webinars. This is something that the regulator will look into. Lastly, we'll break, when you see on the, as you can see on the agenda, we'll break at 10:25 for 15 minutes, and again at 11:35 for a 30 minutes lunch break. The webinar is part of the installation batch on arrear contributions, and the purpose of this initiative is to create an engagement space between the regulator and the industry. Today's webinar is basically an extension of the previous webinar that took place on the 18th of July 2023, where we set the legislative scene by unpacking Section 13A of the Pension Funds Act. We looked at prescription in relation to arrear contributions. The adjudicator gave us statistics on the nature of complaints finalized in 2022-2023, and we saw how high complaints in relation to Section 13 compliance were. We also went through registration, deregistration, liquidation of participating employers. Today, we'll look at the trends by the Office of the Pension Funds Adjudicator. We'll look at industry challenges and successes, fund experiences and opportunities. We'll also have a presentation on Conduct Standard 1 of 2022. Thank you again for joining us, and we hope that this will be a fruitful session for you. Ladies and gentlemen, without wasting time, let's get to it. I'd like to call upon Mr. Silas Mothupi, who will take us through the trends by the Office of the Pension Funds Adjudicator. Mr. Mothupi is a senior assistant adjudicator team leader who is tasked with dealing with the merits of complaints received by the Office of the Pension Funds Adjudicator. Mr. Mothupi, I can see that you are ready. You've already taken the virtual stage, and over to you.
Thank you. Morning, everyone. Julia, you can reflect the presentations if you have it.
Yeah, can I ask you to share the presentation on the screen?
All right, let me try to share.
Good morning, everyone. Can you just confirm that you can see the presentation?
Yes, I can see.
Okay.
Yeah. You can move to the next slide, please. Yes, let me introduce myself first. My name is Silas Mothupi. I'm one of the team leaders in case management. I'm not alone. I'm with the Deputy Pension Fund Adjudicator, Naim Esop, and Tepotuga, one of the team leaders. I'm just going to highlight some of the trends and cases that we adjudicate relating to Section 13A. As we all know, payment of retirement fund contributions are regulated by the provisions of Section 13A, read with the FSCA Conduct Standard 1. I'm not going to delve deeper into the legal provisions, as we all know. I see there's a separate presentation dealing with the conduct standards. So I'm going to move straight to cases and trends. You can move to the next slide, please. I thought I should just highlight, can you please move back to, yes, thank you. I just want to highlight some of the duties that employers must comply with in relation to payment of contributions. Now, firstly, a participating employer has a duty to pay contributions that must be deducted from the members' salaries every month. Now, we have seen cases where some employers either do not deduct or they deduct but not at a correct rate. So those are some of the cases that we come across in relation to deduction of contributions. Or they don't even register people with the fund, despite being required to do so in terms of collective agreement or the fund's rules. Now, also, the employer has a duty to submit schedules when it pays contributions so that the fund can allocate contribution accordingly. So we have seen cases where employers don't submit schedules timelessly or at all. And then funds struggle to allocate contributions to relevant members. Now, a defaulting employer also is liable to pay late payment interest if it fails to pay a contribution timelessly. A number of complaints shows that members either don't contribute, like I said, at the correct rate in terms of the rules, or they don't understand, even know that they are liable to pay late payment interest. So most of the members only realize after exit from service that the employer has not been paying contributions because they are not provided with information, because the employer doesn't either inform them. You can move to the next slide. Now, a fund, on the other hand, has a duty to take reasonable steps to ensure that contributions are paid timelessly. Reasonable steps can even include informing members if a particular employer is non-compliant. We have seen cases where, like I said, members are not aware if the employer is not compliant with this, in terms of payment of contributions. So the fund has a duty to take all reasonable steps to communicate relevant information to members, including if a particular employer is non-compliant. It is common practice for funds to send communication to employers' HR department. But we have noticed that most of this communication doesn't reach the members because the employers don't distribute those communications. So it remains the duty of the fund to ensure that whatever communication it sends to either members or employers, the communication actually reaches the members so that they can exercise and protect their rights. You can move forward, please. Now, we have seen cases also where funds are not able to allocate contribution correctly either because their data is not in order. Because a fund has a duty to allocate contribution to members properly so that they can know which they can have proper records in terms of each member. Now, we have come across in recent times some funds that do not have proper data in terms of allocation, payment of contribution, either after a change of administrators or mostly in relation to changes in administrators. I can mention a few, but let me avoid mentioning the names. And we have been having difficulty in terms of adjudicating these complaints because funds are not able to give us schedules or information regarding the complaints because they don't have the data following changes in administrators. So it remains the duty of the fund to keep proper records in terms of payment of contributions and allocations of contributions. And now in most of these cases, we have been forced to issue default determinations because funds are not able to give us information when we request it because they don't have proper contribution records. They don't have proper data. They can't even tell us the fund credit, whatnot. So although they can appoint an administrator to administer a fund, it remains the duty of the fund to keep proper records. So we have adjudicated quite a lot of complaints relating to this issue. I hope you can all hear me. I hope I'm still audible.
I can hear you, Mr. Mothupi.
Yes. So we have seen cases like this where funds are not even able to issue benefit statements or even pay benefits because they don't have proper records. This has emerged as a trend recently. As I'm talking to you, I've got files in front of me relating involving one fund that simply doesn't have records. They can't tell a member that we hold this much as a fund credit, we hold this much as your contribution, because there's simply no records. Or somebody suggested that I switch off my camera. Maybe the audience, let me switch off. You can move to the next slide, please. Oh, yes. Now, some funds have resorted to lodging complaints against some defaulting employers. Although this is allowed in terms of the Act, the fund still has to take other reasonable steps to ensure that contributions are paid timelessly. In some instances, like I said, the delay in taking appropriate action result in some employers going into liquidation or business rescue. And as a result, we are not able to assist complainants because we don't have jurisdiction to order any company that is in liquidation to pay any contributions. So the delay in terms of communicating to members or informing them or taking appropriate action has a ripple effect in that we're not able to assist them when they approach the office because by then the employer is either in liquidation or they've closed their business or they're in business rescue. Now, PSSPF, Private Security Sector Provident Fund, remains the fund with a high non-compliance rate. I think in the office, we still receive approximately 70% of complaints relating to PSSPF. So it remains the fund with a high volume of complaints relating to Section 13A, where participating employers either do not register their members with the fund or they don't pay contributions every month, or they delay in payment of contributions. Next slide, please. You can move to the next slide. Yeah. Now, like I said, can you move back, please? Yes, thank you. Now, like I said, recent determinations show that communication is very critical. This is because prescription apply to RE contributions. In other words, as it was confirmed in the matter of Ghani, each non-payment of contribution is a wrong on its own, as what was held in this ruling. So in other words, prescription runs against RE contributions. So communication is very critical so that people can take appropriate action before prescription runs against their claims. In recent determination, we have been applying this principle. We assess when the complainant was aware or ought to have been aware of non-compliance in terms of Section 13A in order to determine whether the claim is prescribed or not. So it's very, very important that members are informed on time if the employer is non-compliant, so that they can take the lodge complaint on time before prescription runs against their claims. Very, very important. Communication is very important in this regard. You can move forward, please. Now I'm going to move on to some of the cases, recent cases that we adjudicated recently. This one was issued in February this year. It relates to non-payment of contribution which affected payment of a risk benefit, in this case, a death benefit. Now, the complainant was dissatisfied with the non-payment of a death benefit following the deceased death. Next slide, please. Now, the fund was unable to pay the risk benefit due to the failure of the employer to pay contribution from May 2020 to June 2020 and July and January 2022. Now, it's obvious that because the risk benefit cannot be funded due to non-payment of contributions. So in this case, you can move forward. The employer was ordered to pay RE contributions, and it was also ordered to pay the risk amount of 267,000 in order for the fund to pay the risk benefit, which is a death benefit. So in cases like this, where a fund is not able to pay a risk benefit due to non-payment of contributions, we normally ask the fund to give us a computation of the period of a recontribution plus late payment interest, and to give us a computation of the risk amount that will have been payable if all contributions were paid. So in this case, we will order the employer to pay the risk benefit that will have been paid if all contributions were paid, it's just like in this one. So that is the critical part here, that we're trying to avoid the situation where a member suffers, they lose their risk benefit due to the failure of the employer to pay contributions. You can move forward, please. Now, this is another case. The complaint in this case was lodged by the principal officer against a participating employer for non-payment of contributions. The PO stated that the employer was in arrears for June 2021 to March 2023 in the amount of 191,000 plus late payment interest. Now, in this case, the PO provided the identity of the person responsible for payment of contribution as the director of that company, Spectra Spray. So in this case, they provided us with details of the identity. Remember, a director or a member of a closed corporation can be held personally liable for payment of RE contributions. So in this case, they provided us with the identity of the person responsible at the company. Next slide, please. Yeah, like I said, in terms of Section 13A8, a director of a company can be held personally liable for non-payment of contributions on behalf of members. Now, in this case, the employer and its director failed to ensure that contributions were paid to the fund, which resulted in prejudice to members in terms of their benefit entitlement. So they were jointly or held liable to pay a re-contribution in the amount of 174,000. We rarely issue orders like this where we hold a director personally liable, but in this case, the director was held liable jointly with the employer to pay a re-contributions. The next slide, please. Now, this one it relates to payment again of a death benefit, the insured portion of a death benefit. The deceased passed away on 7 February 2021, and the deceased was a member until his death. He was a member of the fund until his death. So the beneficiaries lodged a claim for a death benefit. The fund refused to pay the insured portion due to non-payment of risk contribution and late notification. Next slide, please. Now, one of the beneficiaries lodged a complaint claiming that the employer failed to pay contributions and the fund failed to hold the employer accountable in relation to payment of contributions. And as a result, they suffered a lot in terms of the risk portion that was supposed to be paid following the death of the deceased. Next slide, please. I hope I'm not moving too fast. Now, the deceased, the fund submitted that the deceased was its member until his death in February 2020, and it only received notice of his death in February 2021. It only received the full claim documentation in April 2021. As a result, the underwriter repudiated the risk portion due to late notification. So there are two issues here: non-payment of contributions and late notification of that. Second, and next slide, please. Now, the adjudicator held that the employer had a duty to submit the death notification to the fund within 6 months of the deceased death. In this case, the employer failed to submit the notification on time within 6 months. So the employer was liable to pay the risk contribution as the deceased was on sick leave at the time of his death. The employer submitted a defense that no, this person was absent from work without notice, but they never actually terminated his employment. So we discovered that he was actually on sick leave. So he was still employed, basically. So the employer was held liable to pay the risk contributions and to pay the insured portion in the amount of 275,000. Next slide, please. Now, in this matter, it involved PSSPF, the private security sector. The complainant was employed as a supervisor from November 2019 to November 2022. Now, you remember that in terms of the main collective agreement in the PSSPF, people who are employed as managers are not eligible for membership of the fund. But this one was employed as a supervisor, but was registered with the fund. The employer participated in the fund. Next slide, please. The fund, in its response, stated that the employer is non-compliant. Remember, this person is not eligible for membership. That's first. That's the first thing. The fund said it holds a fund credit of 11,000 something, and they actually said the employer is in arrears with contribution from November 2021 to November 2022. Now, this on its own shows that this on its own shows the fund is not able to, doesn't understand its own rules in terms of eligibility for membership. Next slide, please. Now, we conducted a search on a company on the CIPC side, which shows that the company is actually in voluntary liquidation. And we also held that the employer is not eligible for membership as she was employed as a supervisor, not a security officer. And we hold that deduction and payment of contribution was unlawful. So the fund, we ordered the fund to refund the contributions to the complainant and the employer. I must say we have come across a lot of these cases, especially in relation to PSSPF, where people who are not eligible for membership are registered, and then we normally order a refund of contributions. Next slide, please. Yeah, now I just want to highlight some complaint stats and trends during the year 2022 and 2023. Now, on this first slide, you'll see death benefit were about 6.56%. The others are just very low percentage. Disability, maintenance, pension interest, very low. We receive a very low number of complaints relating to those. Next slide, please. Now, as you can see on this slide, most of the complaints still relates to Section 13A compliance and payment of withdrawal benefits. So Section 13A compliance, 33%, withdrawal benefit, 50%. Now, most of the complaints relating to withdrawal benefit also have an element of non-compliance with Section 13A. So a person will say, there's a delay in payment of my withdrawal benefit, but when you investigate the matter, you actually find that the employer was non-compliant in terms of payment of contributions. So I can say about 70 or so percent relates to non-compliance with Section 13A. That's the majority of the complaints that we adjudicate. The others, retirement annuity, Section 14 transfer and claim, there are very few, and disability benefit, very few. So next slide, please. Next slide, please. Yeah, no, I think that's the end of the presentation for me. I don't know if any of my colleagues wants to add anything.
Mr. Mothupi, thank you so much. I was waiting for an indication whether some of your colleagues want to add or not. Thank you so much. Ostepo?
Yeah, there's Tsepo.
Thank you very much. Good morning, colleagues. Can you hear me?
Yes.
Okay. What I want to mention also is that we do come across a lot of complaints where funds are not allocating contributions. Even if employers provide us with proof that contributions were paid, still funds don't even respond to say whether they've received the contributions or not. But it will be indicated that the employer owes contributions, even though proof of payments were made. So that is something that needs to be taken seriously. And where we see that, we notify the FSCA of the conduct of the fund. That's all I wanted to say. Thank you.
Thank you, Ostepo.
Julia, sorry.
Yes, Mr. Mothupi, yes.
I just wanted to add another thing. During COVID-19, some funds amended their rules to grant COVID relief to some employers in terms of payment of contributions. But we have seen that some funds didn't actually amend their rules, or they don't monitor the period, the COVID relief period in terms of payment of contributions. If an employer says, no, I was granted relief until March this year, but the fund still says, no, the employer is not liable, but the period has lapsed. So the funds are not, some funds are not monitoring that COVID relief period. Normally, employer will be liable for risk contributions only for that period. Thank you. Thank you.
Thank you, Mr. Mothupi. We have a hand from Jaya.
Thank you for that presentation. It was very interesting. Mr. Turner, you said that the fund is responsible and liable for communicating non-payment to members, which is obviously the case in terms of the conduct standard. And then you said that the fund is responsible for actually ensuring that members are receiving those communications. So I wonder if you could just say a little bit more about that in light of the fact that the fund relies on contact details that are provided by the employer, which may not always be correct. So what is actually the responsibility of the fund in ensuring that the data that it receives from the employer are details that are actually going to result in members receiving communications?
All right. You see, in terms of the Pension Funds Act, it's the duty of the fund to provide relevant information to members. This is in order for them to exercise and protect their rights. Now, some funds employ, the different funds employ different methods in terms of issuing communications. But in adjudicating these complaints, we noticed that most of the funds will submit the communication to the HR department of the employer to distribute to the members. But that doesn't happen because the employer doesn't distribute this to the members. As a result, the information doesn't reach. For example, benefit statements are issued annually, but you'll receive complaints saying, no, I never received a benefit statement. And then the fund says, no, we submitted this with the fund. The fund cannot say it has discharged its duty if actually the information, it doesn't ensure that the information reaches the members. The other way of ensuring that it reaches members is to use their email address. But most of them, some of them might not have email address. Or to distribute them themselves, somehow go to the employer, distribute them somehow. But the ultimate, the bottom line is that the fund has to ensure that the information reaches the members. It doesn't matter what method you employ, but it must ultimately reach the members. I don't know if I've answered you.
Yes, thank you. Thanks for that.
Thanks, Mr. Mothupi. There's a hand from Anna Marie.
Yes, thank you so much for the presentation. Mr. Mothupi, I just want to find out how recent are these complaints? Is it, prior to the conduct standard, the latest conduct standard, or is there evidence that even subsequently that this behavior is still continuing?
Yeah, most of these determinations that are referred to are quite recent, from February this year. Some of them July. So some of them are after the conduct standard. So the behavior in terms of non-compliance continues. We haven't seen any major change in terms of compliance with Section 13A, particularly in the private security sector, the contract cleaning, those major sectors. There continues to be a high level of non-compliance. It's like one day I had a discussion with one employer. This employer started a security company. He has absolutely no clue in terms of the regulatory environment he's operating in. But he's starting a security company. He doesn't even know that he must register with PSSPF because it's compulsory unless you are exempted. So they don't understand the law in terms of compliance with this section. Members also do not understand what they can do in terms of protecting themselves. So from our part, as the Office of the Pension Fund Adjudicator, we have embarked on some public awareness, consumer awareness programs in order to educate the members, particularly those in far-flung areas like townships, rural areas, about some of these issues. We go there, communicate with them using their own language. So that's what we're doing from our part in terms of alerting members of some of these issues. Thank you.
Thank you so much, Mr. Mothupi. There's a question from Wanda Masheho in the comment section. And it reads, in the first case, boy, what justifies employer being ordered to pay all risk premiums not paid
Yeah,
when the employer is still being ordered to pay the full risk benefit?
yeah. In that case, the employer was non-compliant in two respects. Firstly, it did not pay contributions. Secondly, it affected the risk benefit, payment of the risk benefit. Now, the fund cannot be held liable to pay the risk benefit if it did not receive the contributions from the employer. So therefore, who is the liable party here? The employer. The conduct of the employer resulted in prejudice to the member in terms of their benefit entitlement. So that's why it's only fair that we order the employer to pay what is owing in order for the fund to discharge its liability in terms of payment of the risk benefit.
Thank you so much, Mr. Mothupi. Wanda, I'm not sure if that answers your question, but if you still want Mr. Mothupi to elaborate, you're welcome to raise your hand and unmute yourself. Mr. Mothupi, we have a question from Wendy, and she says, often members change SIM cards and cell phone numbers. What about members who do not have email address and members who are in far away remote areas where not necessarily accessible?
Yeah, we have had several meetings with funds raising the same issue. What we encourage that funds do, well, you can do different things, but what we encourage you to do is that you ask members to update their records at least once a year, so that you've got updated contact details, email address, or their addresses. So that if you don't update those at least once a year, obviously they will move around, they change their telephone numbers, their address, and the like. So, but if the fund can show that it has taken reasonable measures in terms of communicating, and they've updated their information on a regular basis, their data, they've taken reasonable measures to ensure that the communication reaches the members. We assess each case on its own merits to see what steps or reasonable steps the fund has taken to issue the communication. But I'm just saying one of those things is to update your membership records at least once a year so that you've got updated information.
Thank you so much.
Thank you.
Oh, no, it's fine. You can continue.
I'm saying we also struggle here when we adjudicate complaints, because when they file a complaint, they give us an address, a telephone number. By the time we adjudicate, the information has changed. So what we do, we follow up. We follow up to ensure that we get updated information.
Thank you, Mr. Mothupi. Ostepo?
Yes, I wanted to add that we also experience similar challenge with regard to change of address. But updating member details on an annual basis can also assist the fund in having the recent contact details. Thank you.
Thank you, Ostepo. Kiabetsu?
Thank you, Julia. Yes, just to piggyback on what Silas and Tsepo have said, at the end of the day, Wendy, it's that funds need to take, reasonable measures or reasonable steps to communicate with members. So we understand that a member might have multiple numbers and so forth, but at the end of the day, has the fund taken reasonable steps or measures to communicate with their members? And I think my colleagues can also attest to the fact that, when we speak to some funds, we do hear of cases where members don't necessarily want to provide their employers with said information. But we deal with that on a case-by-case basis. But at the end of the day is, take the reasonable steps to communicate with members. Thanks.
Thank you so much, Kia. There's a comment question from Mimosia, and it reads, in terms of non-payment of contributions, by the employer. What if the employer is notified but the behavior of non-compliance persists? What are the steps that the fund should take after informing the employees and the late payment interest letters were sent and there's still non-compliance? Mr. Mothupi?
You mean if the fund has complied with the duty by notifying the members of employers' non-compliance, but the non-compliance continues?
Yes, the employer continues to default.
One of the ways is for the fund can lodge a complaint with us. We do receive complaints from funds. Normally they are represented by the chairperson of the board or the principal officer can lodge a complaint. In fact, if the fund lodges a complaint, it saves us a lot of work in terms of receiving individual complaints. Or they can advise the members of their rights and the actions they can take, which one of them is to lodge complaint with our office. But it's more effective if the fund lodges a complaint against a defaulting employer so that we can then dispose of the complaints like that. The fund can give us a computation of how much for the period the employer has been non-compliant and the arrear amount plus late payment interest. They can also do the report to the FSCA in the normal way. So one of the way we can assist by the fund lodging the complaint with us. It doesn't necessarily have to be the members who lodge the complaint. But I think the funds on their part needs to have some information sharing session with the members on a regular basis. It can be in a different form. It doesn't have to be in person or by emails or by letters. They need to have some form of information sharing session where they explain these things to the members. And thank you.
Thank you so much. Logi, Govinda said that there should be a greater awareness created in the retirement funds industry for members to update their details with their respective employers as soon as possible. And I see that also, there's another person who touched on, I think it's Naeem, the deputy adjudicator, that the conduct standard requires that the contact details be updated regularly. And there's a question before I let you go, Mr. Mothupi. There's a question from Lindsay, and the question is there a standard format provided, including annexes to lodge a complaint with the OPFA? Is it I'm not sure if this is a complaint in relation to arrear contributions or just the normal complaint with the OPFA, but is there a standard format to lodge a complaint with the OPFA for arrear contributions?
Lani?
Yes.
Can you just check something on Chris for me quickly? If this member is
Tonika, can you please mute yourself, please?
Get out there saying my license card is going to
Mr. Mothupi?
Yes.
Is there a standard format provided to lodge a complaint with the OPFA?
We try by all means, we try by all means to avoid prescribing a particular format. But there are some relevant information that we need when a fund lodges a complaint against an employer. You must clearly state the facts, the non-compliance in relation to Section 13A, the period of non-compliance, the amount, and late payment interest. And but maybe the DB can come in here, but we're not really prescribing the full requirement, but as long as the essential information in relation to the period of non-compliance, late payment interest, the amount, and the like, and what the employer has done, what you have done as a fund in order to take reasonable steps to ensure that contributions are paid. I don't know if Naeem, you want to add, or Tsepo?
Tsepo, before Naeem?
Yes, the other information that we will need from the fund is to be provided with the name of the responsible person at the employer who is responsible for ensuring that contributions are paid to the fund.
Okay, thank you, Seppo.
Yeah, the DP said that we have covered everything. Yeah.
Okay.
Yeah.
All right.
Yeah. Yes.
Yes, Mr. Mothupi.
Yes. Yes. Now I was saying though we have covered everything. If there are further questions in this regard, any person who requires further clarity, you can. I will come to send me an email as well. We can
All right.
take it further.
Thank you so much, Mr. Mothupi. Can I just confirm if you will be online with us until 1:30, just in case there are questions relating to your presentation, maybe?
Yes, yes. Also, the DP just indicated that the Induplam rule applies to payment of RE contributions. In other words, the amount of late payment interest cannot exceed the capital amount. So the funds will take that into account.
Thank you so much, Mr. Mothupi, for an informative session. I get so excited when we, get questions from, the attendees. It shows that we are really involved. We are all, taking this seriously. And thank you so much. You basically echoed the sentiment that we are all responsible to play our part to ensure the protection of members. And by we, I mean all stakeholders, be it employers, funds, and the regulators. And we are all aware that the authority is currently collating information on errant employers. And from our experience, the site, we have seen funds, reporting on arrear contributions in line with the conduct standard. So I think this was good discussion, and thank you for the presentation.
Thank you. Thank
you. Ladies and gentlemen, we are moving to our second speaker. Our second speaker is Ms. Annie-Marie Dalton. Sorry if I'm butchering your surname.
No, it's correct.
Yeah, so Ms. Annie-Marie Dalton is the CEO of the Council of Retirement Fund South Africa, known as BATSETA, and is a very familiar face to, I think, most of us here. And she'll be giving us a view from the industry at large and not necessarily fund-specific information. Ms. Dalton, you may take the virtual stage.
Thank you, everybody, and good morning. So what I will be doing this morning is just to give you some feedback. I had conversations, especially with the Umbrella Fund Forum, to just get some information about the progress made with implementations, where are the kind of issues that it's bothering them, or whether, we are actually just on the right track. So thank you very much for this opportunity. So it's anecdotal in most instances. So hopefully it's more the words of the funds participating or that I engage with rather than BATSETA itself. And I thought the best way for me to do this morning is just to follow, the issues in the conduct standard. Sort of what is it that we were worried about in the beginning before the issuing of the standard, what transpired in between, and then, maybe what are some of the opportunities that we have. So I hope that I will be able to do this within the time. It might be a little bit shorter. So looking at the employer establishing or participating in the fund, the issues about, notifying the fund, the employers about their duties, obligations, and liabilities. And in our conversations, this is basically one of the most important steps that one should take, because, an employer, after you have done this, you have issued this communication, cannot come back and say, well, I did not know. Although ignorance of the law, obviously, is not an excuse. And it is really just a good practice to address any misunderstandings. And I've asked, the funds, to what extent do you receive any feedback from this? How is it received by the employers? And, is it just seen as an administrative process? And so the feedback around this, that it's not really a big issue. It's actually just a non-issue. employers do acknowledge receipt of, this a notification or the annexure. But there is sufficient flexibility to execute, to notify, and to report on an annual basis. This is also what the funds indicated here, that this is also a proxy of future cooperation and collaboration. So, funds who do respond, acknowledge, and say, I took note of this, it's more likely to be compliant. And, for others that stay quiet or do not engage, you most probably find that there might be problems going forward. Right, then the next issue is the issue around member information. So, prior to the publication of the conduct standard, there were a couple of issues that the industry raised. There's a requirement to say, please, we need more time, a transition period. I think some funds indicated we actually need 24 months to implement and to get our systems in place. Because there's a lot of system changes required, and we will not be able to implement properly unless the systems are updated. There were also a lot of uncertainty whether the full suite of information will be obtained. So in other words, what kind of information will be readily available and accessible through the employer or even the members. And there was also sort of a sense to say, but at least we should be able to get one contact detail, whether it is a cell number, whether it is an email address, whether it's a postal address, so that at least there is a way to communicate. Some of the funds also indicated, that not all members are required to register for SARS, for a tax number. And that might be really problematic, and that funds will now be punished if the employer failed to submit information. When we look at the FSCA responses, to these sort of concerns that were raised, is to say, yes, we are aware that there's a transition period required and system changes required, but that does not mean that you can continue looking for information and gathering the necessary information. So yes, acknowledging that system changes, it's actually necessary. There's also provision that not all the information will necessarily be compulsory, but obviously ID numbers, SARS numbers, are very, very important, not only in terms of Section 13, but also in terms of death claims, in terms of Section 14 transfers. So certain information you actually can't do without. I think we have discussed this issue around funds need to take reasonable steps. And hopefully, during this presentation, it will become clear whether those reasonable steps are taken or not. And then, there was a whole conversation around what to do with employers who may refuse to provide the necessary information. And there was, again, just confirmation that if employers do not submit the necessary information, that they are in contravention of the standard, and obviously then open themselves up to further to prosecution. So having said that, what we have done was then to say to the funds, listen, these were the kind of things that you worry about before. What is happening now? What are you busy with? In terms of implementation, and do you still experience some challenges, and is it related to the kind of things that you have raised in the consultation period? And I think what the funds basically said to me was, Anne-Marie, I think something that we need to consider, and that FSCA and everybody around the table should take note of, that this is a huge project. The scope of this project is basically huge to gather the information if it's not there. There are funds with 5,000 participating employers and about 613,000 members. There are smaller umbrella funds with 100 participating employers and about, say, 39,000 members. But whether it's a 5,000 participating employer size or whether it's 100, it is still substantial. So the request here is not necessarily to say, well, we cannot do what you ask us to do, but just to say, but please be patient. It is not an easy process. In terms of the transition period and the system updates, it's, it's still continued. There are other ways to collect the necessary data. But, sometimes it is still a manual process. Lots of resources are required, time and money. And, it is, although they were not able to really quantify, how many resources, how much time and money is required to get through this process. But again, it's just the plea to say we are busy with this. It is something that we're spending a lot of time on. So it's rather a statement of a fact than a complaint that we cannot do this. There is also agreement and a recognition that this process is a necessary exercise, and that it is important to get the money, but there are lots and lots of moving parts. And I think, if you look at the presentation that we just had, it's not very easy. Some of the issues that impact the ability to collect minimum information is obviously, the payroll systems, and whether it's a large employer, a medium employer, or a small employer. They found that, if the payroll is managed in-house, the information is more readily available. If it's outsourced, it becomes a little bit more difficult. And then some employers, the really small employers that's really busy and doing payroll via a spreadsheet, Excel spreadsheet process, that is, not sometimes easy to get that information. And then obviously, like we have indicated a little bit earlier, if there are employers who just want to hide and don't want to participate, they will actually find ways to do so. So this was just a sort of an important message from the funds that I engage with, is that we are busy. It is something that we take seriously, and we are trying to collect the information. They also found that, in this process, that lots of the information is actually outdated, and that there's a discrepancy between the information that the employer submits and the members' live data. So where the funds were able to actually engage directly with members, and I think it was also mentioned, the information differs. Tax numbers are actually the biggest issue. I think there was an example where, I was told that one of the members actually arranged that their contribution is paid or into a third-party account for fear that the fund will disclose information and that the SARS will come and pray into their bank accounts. And it took quite a bit of education to say, but it is not the role of the fund to report you to SARS for any other reasons except for making sure that you can receive your benefit. So there's really a huge educational effort going on to inform members about their rights and their responsibilities. There's also an issue, quite a challenge when you deal with foreign workers, especially those from Mozambique. There is an issue at the moment around the extension of the permit periods. And, as soon as you deal with some foreign workers, there's a challenge with respect to documentation and the verification. It was also mentioned a little bit earlier is, there is definitely a trust deficit when it comes to the employer and employees. It seems as though employees not necessarily want the employers to know too much about their whereabouts, which I find actually quite strange because, I mean, you are employed and you should be able to give your personal information and make that available to your employer. But it is unlikely for a member to voluntarily update information with the employer. So unless the employer is at it all the time and regularly asks for updates, it is not likely to happen. It also seems that the conduct standard do not really, the issuing of this conduct standard do not affect delinquent employers. You know, they just continue to do so. They despite warnings about, you know, the potential consequences. And here I want to just sort of, we spoke a little bit about the naming and shaming kind of issue that is still very much in the air. And that, you know, there was an indication we have submitted information about delinquent employers, but there is no feedback from FSCA in terms of, you know, what will happen, what are the next steps, how will this information be used? And then also some concern raised that, you know, there's been quite a lapse in terms of period since information was submitted, and, you know, will there be another opportunity just to update information in the event that employers paid in the meantime. Also then, you know, the issue of criminal prosecutions, a lot of inefficiency in that particular space. And, you know, there is an indication that it will take really a long time to see the results. And obviously a huge issue in the respect of consequent management. So if you don't submit the information, there is a contravention. You really need to go through all these processes before you actually get to, you know, lodge a criminal case or see the results of consequent management in this respect. So what is happening in practice? What is it that the funds are saying they are doing to look at this particular issue? And I think the first issue that they are saying is relationship management. You know, it is in the interest of the fund, the administrator, the employer, and the member to collaborate. And that the funds that I spoke with say this is something that they are focusing on now. You know, it is a collective effort. It is not only the fund or the administrator that is part of this particular process, and that if they deal with the members directly, it seems as that they are more successful and that members are more willing to give information. So they are utilizing various and all avenues to obtain and update information. And it seems that the best way to do so is through the fund portals or by creating, you know, WhatsApp facilities so that members can ask about their fund credits. You know, that is the carrot. They say it's a very good carrot to say, well, inquire about your fund credits, just get information about, you know, what it looks like. And they use that opportunity, you know, to just get information. And as soon as the fund receive that, obviously share with the administrator as well as the employer to make sure that it is done. Onboarding is also a very good opportunity, provides a good opportunity to collect information. There are wellness days. But I think what the funds are saying here is that you really have to stay at it 24/7. It is not something that you can do once off. You really need to make sure that everybody is aware of this all the time. And, you know, if you use various avenues, if you really raise awareness, if you stay at it, your rate of success is very much higher. I've asked some of the funds, you know, please tell me, what is your rate of success? Can you tell me what your rate of success is there? And some said, okay, they will come back and share that with me. And I will obviously share that with you as well. I'm also not sure whether the FSCA in terms of, you know, the upload of information and the reporting systems will be able to also give us the industry an indication of what is transpiring. Coming back to naming and shaming, which was a bit of a discussion, is to say, are we ready for such a particular intervention? Should we not rather look at best performance versus worst performers? There are so many, like they indicated, moving parts around this, but one thing is agreed to or necessary is that something needs to give, and that this kind of process might be helpful to encourage employers to really take this issue serious. I am very surprised that, even after the conduct standard, that the adjudicator's office still say, it's the same old same. I was hoping that, it was maybe just older cases that is now still processing. In terms of the reporting issues, prior to the conduct standard, there was a lot of issues that were raised, concerns to say, the exclusion of reporting of discrepancy, that, if there's a 2.5%, I think, threshold to say if it's not material, you don't have to report on that. And some funds is no, you have to report on absolutely everything. That, should this reporting be monthly, reporting of the contraventions, which is still unresolved. It basically says no, you don't have to report on any others, only those who are unresolved. There were sort of issues around reporting periods and the materiality of the breaches, to say some of the reporting periods might be too short, others might be too long. And there was even a warning about reporting fatigue. And there was also suggested explicit requirements in terms of communication of underpayments and communication with the employer through either joint committees or with members regarding non-compliance. So those issues were already raised, before the conduct standard became effective. Then also there was an issue raised to say that please prescribe the content of the notices to members. It will just make it a little bit easier. And members must also have the opportunity, employers must also have the opportunity to correct and make the necessary payments, and, maybe put a payment plans and so on in place. So I think in this, when we look at the FSCA responses in this respect, I think there's a lot of flexibility in terms of the reporting periods, and funds need to just basically decide how they want to deal with the communication, whether, whatever means they use, it is just important that it basically takes place, and that the FSCA does not necessarily want to be too prescriptive in terms of, what needs to be and how communication needs to take place with the employers. I must also say that, in our conversation with about the reporting, some of the challenges is say that, there's a sense that delinquent employers just continue with the behavior. They are not really too much worried. It's either because it takes a long time to prosecute, or maybe it takes a long time to really find the employers or to do something about it. Some employers, pay not necessarily every month, but they do pay. It's almost, I think they use the word of skip one, knit one, used to assist the cash flow and so on. And there was also an issue raised that the FSCA system upload sometimes problematic, or that they are in trying to resolve issues around the uploads, that there's changes in email addresses and notifications that you need to take note on. In terms of the reporting, members also indicated that the board would, there are various ways in terms of reporting, and this comes back to this reasonable steps taken. I think one of the funds indicated that, sometimes they do write a letter under the signature of the chairman, which they found was quite useful and effective. They had some success with that. So maybe some of the funds who are sitting here who struggle, that might be one of the ways that you can also consider going forward. that, you know, in terms of the reporting requirements, that there is follow through, that, you know, the funds are taking the necessary steps to meet the periods, although some indicated that it's sometimes onerous. You still need to remember that, you know, it's 5,000 employers or 100 participating employers that you are dealing with, but that the support from the FSCA when there are problems, it is there, and that they actually just indicated their appreciation for that. The big issue, and I think the biggest complaint in our discussions relates to reporting to SAPS, South African Police Services. What was sort of looked at, and I think, you know, even if you look at the consultation or the responses during the consultation period, it is still similar. SAP's inability to really just render the services, you know, some funds say they queue for hours and hours. There is really a lack of understanding of the regulatory framework. You know, they don't want funds to pre-prepare affidavits. You know, the officer needs to literally sit and do it themselves. And there is generally an unwillingness to open the cases. So the fund's understanding, there's also a problem with the fund's understanding of the reporting waiting periods. It's unsure, you know, when to actually raise the issue with SAPS, and, you know, finding that balance of reporting too early or reporting too late, it's not easy. Then also, you know, there's a requirement or a request that the consultation with SAPS and the MPA via FSCA is something that needs to continue. And it's not really clear to what extent is this happening and how it affects what is happening at a reporting level. So there are really potentially high numbers of contraventions, a lot of that within this particular space. And, you know, if there's inefficiencies in reporting to SAPS, you know, it will obviously impact the ability to deal with the issues. And there's also quite a feeling that, you know, SAPS first need to be operationally ready for the support. Which they feel it's not necessarily the case. So, as I have indicated, you know, there is no change in this, the views expressed. Some funds did indicate mixed successes dealing with SAPS, especially, you know, if they deal with a very big case or there's an attorney or somebody else that, you know, can assist and has a little bit more experience around the scene. But that they funds also indicated, you know, another issue which I thought was a little bit unrelated, but then I think I understand why it was mentioned here, is that there's also a bit of a reluctance by the funds to really get to the prosecution or the SAPS level, because they are still dealing with funds who are in distress. And, you know, the first preference is to rather find a payment plan, put a payment plan in place, or, you know, find other solutions. So it's a bit of almost struggling with a moral dilemma. You know, what do you do in these instances? And then you actually just sit with this whole issue of employers closing companies just to open it under another name later, and that you really just have these serial delinquents. And I think, you know, funds indicated that when they come across that, you know, termination is it's actually the only option to deal with this. In terms of the bargaining council space, you know, I had some conversations around what is happening within that particular space. And I think the biggest issue that they would like to report or deal with is the fact that they do have processes in place via the Labour Relations Act which where compliance orders are issued, and then it's made a court order through the Labour Court. And in this respect, obviously, I think they have made a submission, or is in the process of making a submission, to actually just get exempted from, going to SARS, but rather following a process that is tried and tested within their particular industry. Another important issue is the late payment of interest. And I think, even if you look at all the other issues, this is something that is still very problematic. When you look at the consultation period, I think there was a very specific question asked by IRFA, will this period, when will this be payable? And in that consultation, it was says the first day of the month on which the contribution is due. And that, that fixed prescribed interest rates will apply, and that, issues around payment plans are quite acceptable. So having said that, things has changed since the publication of the conduct standard, and also the publication of the FSCA Communication 15 of 2023, where it actually, just changes the way that our LPI has been treated in the past. So here it says, on the 8th month following the month in which the contributions were due. And obviously the industry holds a different view around that, and it is still problematic, and BATSETA is of the view that maybe this interpretation is not correct, but and that there's actually no change in how this should be treated from, how it was treated in terms of Regulation 33 or even the legislation. So this is a particular issue that, we will definitely raise with the FSCA. I don't think, there will be time for us to debate and continue the conversation today. But it is an issue that we have to address as soon as possible. And from BATSETA's side, hopefully very soon you will get the submission. We have agreed in the Retirement Fund Forum that we will make such a submission, and the FSCA actually appreciated that. When we talk about outsourcing, I think during the consultation period, there were different views. Some said, it is prudent to include an outsourcing provision in the conduct standards, and others said, no, it should not. It should rather be a policy matter. I think from our side, we would have preferred that it's still a policy matter. But there were also requests that there should be prescribed fees and review periods and all of that, contained in the conduct standard. But I think, now that it is there, it is quite prudent that it is there. And I think the value that it's adding, that is someone is watching. There is somebody that, will sort of see if something goes wrong there, or there's some exploitation, or, something does not make sense within that specific period. Right, so having said that, what are some of the opportunities, and I will rush to finalize. System development, we are busy with two-pot changes, and we hope that, that will also take into consideration all the information that is required. It will create a fantastic opportunity because, if funds members say, I would like to access my funds available via the two-pot system, it will create an opportunity to update information. Because it seems that direct engagement with members are, if you have that direct engagement, you are able to get the information, and, encourage members to engage the fund, asking for their credits, finding that carrot that says, come and talk to us. Relationship management is very important. It is not only the fund's responsibility. If you have a good relationship with your employers, your administrator, and other support systems, you are likely to be more successful. I spoke about naming and shaming just to say best and worst performers. You know, people take note of those kind of things and go say, oh, but my employer is the best performance. I'm happy with that, but my employer is not. What is the reason for that? And it might just, you know, encourage members to ask the very important question. We also feel that there should be an appointment of dedicated prosecutors. I have worked for the Department of Labour when it was still a criminal offence not to pay wages. There were dedicated prosecutors. Labour inspectors actually drafted charge sheets, discussed with the prosecutor, and certain days, I remember it was Thursdays, you know, you have your engagement with your prosecutor. If they say continue, then, you know, it will issue the orders, and many times over it was resolved before going to court. Also using the pension fund adjudicator processes seems to be more successful than the SAPS process, and I think there's an invitation to say, yes, please do so. Bargaining counsel should be allowed to follow their tried and tested prosecution processes. You know, an exemption should be an order. And then, you know, just having the engagements like today is really very valuable to share our experiences. And very soon we have the Money Smart Week, which I think will also create an opportunity for us to raise awareness. You know, feedback from the FSCA, the conversations that we are having here, it's very important, but we also would like to hear a little bit more from FSCA around, you know, not only the adjudicator's office, but from you, what are the kind of compliance levels, where are the kind of areas that we should focus our energies, and that, you know, there should be a process of consultation when big decisions are taken. You know, this industry really employ some of the best lawyers, pension lawyers in the world, in my opinion, and that the FSCA should really use this resource that you actually have available quite free of charge. What I realized today in the conversation so far is, you know, where do we focus our energies, and how do we make sure that funds are proactive in addressing Section 13A issues. So let me stop there, and thank you very much for the opportunity.
Thank you. Thank you so much, Anna-Marie. You know, this was very informative, and I'm sure the rest of the people that are here actually enjoyed it. We'll be taking questions or comments. If there are any questions or comments from the audience, if you want to ask Anna-Marie some of the questions, then please do so. But before that, maybe I can give Gia to speak on the reporting. I saw in your presentation, Anna-Marie, you said that funds are actually, you know, reporting, and so far it seems like there's no feedback from the FSC. Maybe Gia can speak to that whenever she's ready. She can just indicate. But in the meantime, we can also take questions. Gia?
Thanks, Julian. Thank you very much, Anne-Marie, for that delightful presentation. It has really given us at the authority, I'm thinking, you know, quite a lot to think about. But just to, at this point, Julia, if I may, provide feedback on the name and shaming. I know the intention for in this webinar, rather, the intention is for me to just give an overview of what the FSCA is going to be doing with regards to Section 13A, but that I'll be giving towards the end of the session. But for now, just to give feedback on the naming and shaming, I think many funds in this sitting in this webinar would be aware that we have gone back to them, asking them for delinquent employers as at the 30th of April, 2023. We have had an okay response, you know, and some funds have indicated that since the 30th, certain employers have paid those contributions. So we are getting that indication. And obviously those type of employers, you know, you wouldn't necessarily name and shame them because it has since been resolved. But it's not to say that we as the authority can't go to that employer to find out really what are the issues, you know, what's with the behavior. We are intending to publish, and I'm hoping, well, I'm sitting and I'm hoping in the next month, but we are waiting for a specific fund to respond. You know, I'm not going to name the fund, but there's a fund we're waiting for it to respond. And once they have responded, we'll be able to just quickly deal with the publishing. And then we will also be issuing a media release, obviously, just to make people aware that this type of list is available on the FSCA's website. So I don't know if that's enough feedback for this stage. What we will also be doing going forward, obviously, is asking funds just to confirm their delinquent employers as at the end of each quarter. So we will be going back to funds and asking to confirm the correctness of the information as at the end of each quarter.
Thank you.
Thank you, Julia.
Thank you so much, Kia. So I guess, Anna Marie, that gives you a picture of what we're working on in the background, and we'll communicate further in due course. Are there any questions for Anna Marie? Are there any concerns? Any Lindsay? Even a comment is we appreciate it.
Thank you.
Please unmute. Great.
Can you hear me?
Yes.
Okay, I'm very thankful to see the part on reporting to SAPS, as it's actually hit the nail on the head for me. I am the monitoring person of a large umbrella, and I also have found that with opening up SAPS cases, I'm dealing specifically with the captain of a particular SAPS station, and they are under the impression that the case should be opened where the employer is actually situated. So, for instance, if the fund is in Port Elizabeth and the employer is actually in Cape Town, the fund should be opening up the case in Cape Town. They are also in consultation with the DPP on their legal team, the police station's legal team. So haven't yet received feedback, but in the interim, we are handing in the cases to the police station, and they are then distributing to other parts within South Africa. But I'm not sure about going forward how that is going to continue.
Right. Thank you so much, Lindsay, for sharing that with us. So I mean, like Gia said, I think for us, we'll see what for the industry, we'll see what the authority communicates going forward. And I'm aware that we are currently in talks with the SAPS, and maybe Teboho, when he speaks on the conduct standard later on, he can speak on the type of engagement we've had, maybe the contents thereof, and how far we are. Maybe it's either that we can touch on it, or Gia can touch on it during our Q&A session. Thank you so much, Lindsay. There's a hand from Sheila. Sheila, please unmute yourself.
Can you hear me now?
Yes.
Okay, thank you so much. I think, Anna Marie, your presentation was very well and informative. There's just two areas that I would want to latch on, and that is in particularly the section in dealing with SAPS. I think seriously something needs to be done with that, and I concur with Lindsay. If a company is situated in a particular area, you cannot lodge that case at any other police station. You will have to go to that particular area. And I think a lot needs to be done in getting SAPS on board, because it is quite a frustrating process. We've done it in some cases already, but I can tell you, having to spend the time in that police station being sent from pillow to post, it is not nice. Having to explain the information and the details, the documents you have, everything is ready just for them to do the affidavits and stuff. It's quite a frustrating exercise, but what can we do? We do it. But I think they need to look into that as well. Then on the area with regards to, before legislation and policies being passed by the FSCA, I think it would be an excellent idea to first engage the funds, because many times it is your your experts that gets involved in these kind of discussions and not the funds. The funds is very little say in whatever gets decided at the end of the day. And then you get stuck into all of these things that requires your attention and that you need to do at the end of the day. But there is just no, say, area that you can go to. Even sometimes the FECA does not respond really to some of the concerns that you would register with them, that you as trustees deal on a day-to-day basis with these kind of frustrations. I thank you.
Thank you so much, Sheila. Before Mr. Diamond goes, I just want to make a comment to say, yeah, so we'll take forward your frustration, and I think you're not only speaking for yourself, you're speaking for some of the people that are here, that
Precisely.
we as the yes, we as the regulator should do better. So that's something that obviously we'll take to the regulator for discussion and see how best we can picture the future for the retirement funds. There was a hand from Mr. Silas, Mr. Mothupi.
Julia, I think it was the other Silas.
Yeah. Can you hear me?
Yes.
Yes, we can hear you.
Okay. Thank you. Around SAPS, I think it's a tautology. Thanks for the previous speakers that have talked about the matter, and thank you for BATSETA to have made it in round. It's a tedious process. When you get there, you'll find that most of the police people or whoever with our officials, that they don't know what to do. Thank you very much. Please work on that matter. It's an uphill battle. Secondly, Anna Marie talked about the companies that default, and down the line, when you pursue them, we got the real CEO or director. Down the line, they vanish in thin air, the company has been liquidated, they are nowhere to be found. Only to find that the company may open in another town under a different name. So it's one of the problems that we are getting around these companies. They do vanish, and then they leave most of the workers in the lurch. That was what I wanted to say. Can I shut up for now?
Thank you so much, Mr. Diamond. I remember we had this discussion regarding lodging cases with SAPS, but yeah, as I said, we'll take it further as the authority, and hopefully we'll give the industry feedback. Anna Marie, thank you so much 1,000 times. I just want to confirm if you'll be here for the rest of the webinar until 1:30.
I will.
Just
Thank
in
you
case there are
so much.
questions.
Thank you.
Thank you. I really appreciate. Ladies and
Julia.
gentlemen, yes, Kia?
Just before we take our break, I just wanna get back to the point Silas has just raised about, employers closing shop and then opening a company elsewhere, or opening a new company. But we are also trying to do. Can you guys hear me?
Yes, we can.
Okay. What we're also trying to do is work hand in hand with CIPC to see what work can we do around directors who are essentially walking away from the responsibility of paying over what's due to the fund and the monies that they would have probably taken from their members. So it is an area that we have identified. People have brought it forward to the authorities' attention, and we're also trying to see what work we can do perhaps with the CIPC around that. Thanks.
Thank you so much, Kia. Ladies and gentlemen, is now almost 10:35. So we can take a short break and come back at 10:45. And then we'll just go through the fund experience and opportunities. Thank you. Welcome back, ladies and gentlemen. Yeah, can you hear me? Thank you. Welcome back, ladies and gentlemen. We hope you're still enjoying the content. I know BATSETA gave us some of the challenges faced by funds and some of the things the FSCA should consider insofar as regulation and compliance are concerned. In the same light and spirit, we have Mr. Roger Spence, the Principal Officer of the Liberty Corporate Selection Umbrella Funds, and he will be taking us through fund experience with regards to Section 13A and the contraventions thereof, and perhaps some food for thought for the authority or the regulator. Mr. Spence?
Thank you, Julia, and good morning to all delegates on the webinar this morning. I think
you're on mute. I cannot hear you.
My microphone is live.
Yeah, can you assist, please?
Can you hear me now?
Am I the only person who cannot hear Mr. Spence?
All right, I see there's delegates are indicating they can hear. So
Panele. Nandi? Mr. Mothupi, can you assist? Are you able to hear me?
We can hear you and Spence, so you can continue.
all right,
Julia.
Okay.
thanks, Johan. Well, good morning to all delegates. I must indicate that I do not have a formal presentation, as I've been requested to provide insights from my perspective of the fund, being a commercial umbrella fund, on this thorny issue surrounding the conduct standard. I must indicate that what I will be sharing this morning are my views as the principal officer and monitoring person, and not necessarily that of the board of trustees or sponsor of the umbrella fund. I must also acknowledge that we have significant collective wisdom in the webinar today, from whom I and others can collaboratively learn much in this regard, as we have already done during the previous discussions. In the context of the webinar, I've been asked to describe the structure of the fund, challenges faced by the fund with regards to requirements of Section 13A and Conduct Standard 1 of 2022, whether there have been any successes in dealing with those challenges, as well as what opportunities could be explored by various stakeholders, including the regulator, to help with reducing and managing contraventions of Section 13A. To start off with, allow me to set the scene of the fund from which I'm addressing the topic this morning. Firstly, in terms of Section 1 of the Income Tax Act, the fund is classified as a retirement fund and structured as an insured umbrella fund and operates as a defined contribution fund. The fund is further classified as a Type A commercial umbrella fund that has been established for the benefit of employees of different unrelated employers. In this respect, a participating employer is entitled to structure the benefits to suit the individual needs of their employees or categories of employees who are members of the fund through the approval and registration of special rules with the FSCA for each of those individual participating employers. These special rules, in the ambit of Section 13A specifically, sets out the contributions that would be due and payable by either the employer or members or both parties, thereby placing an obligation on the employer to collect and pay over the contributions as prescribed in the Pensions Fund Act for the duration of being a participating employer in the umbrella fund. With that said, it means that there's a host of permutations of contribution rates and categories of members among the 5,246 employers participating in our umbrella fund, which needs to be managed by the fund's administrator on an ongoing basis. It's also important to note that in terms of Regulation 1 to the Pension Fund Act, the fund is an underwritten fund that requires that contributions payable to our fund by these participating employers are to be directly paid to the insurer, who has accepted the responsibility to act as administering insurer, as the fund does not have its own bank account, unlike an occupational retirement fund. And therefore, the administrating insurer is responsible for the checking of and accounting of contributions received and reporting thereof to the monitoring person and the fund, while the board retains ultimate accountability in this regard. If I look at some of the challenges encountered and successes achieved since the introduction of the new conduct standard, I think I must first state that I believe that contribution receipting is a vital cornerstone in the retirement fund ecosystem, and therefore it's necessary that funds and administrators alike are adequately empowered to thoroughly manage this within the constructs of enabling legislation that is fit for purpose in the context of the structure of the particular fund or funds, to effectively enable them to administer this component, which seeks to ultimately deliver benefits to members. Why I am touching on this specific point, ladies and gentlemen, is that there are certain nuances between a standalone occupational umbrella fund and a commercial umbrella fund, where you have these multiple unrelated participating employers who form part and whose contributions need to be overseen. Unlike the occupational fund, where you have a single employer, which makes the managing of this much more or less onerous than we have in the umbrella fund. However, with that said, in giving effect to certain aspects of the conduct standard in the monthly billing and contribution receipting process, it was highlighted earlier today that it becomes extremely resource intensive. And in our environment, it is largely driven on the type of payroll system that is deployed by various employers in the umbrella fund. The conduct standard requires that contact details be updated by the employer on a regular basis in their contribution schedule, as discussed at length earlier today. We do believe that it's unlikely that an employer does not have contact details for its employees. And as such, with the introduction of the conduct standard, we were anticipating that employers would largely cooperate in providing the funds administrator with the information of their employees, as stated under Section 3H of the Conduct Standard. As we had requested from employers, especially the member contact details, that is of utmost importance to enable the fund and board to communicate with its members. However, this has proven to be a real challenge, as the fund does not have recourse against employers who fail to provide or update member contact details with their monthly billing schedules to ensure that the fund has up-to-date member contact details. Therefore, I can indicate that from a fund's perspective, post the implementation of the CS, we have not seen a material change in the employer's behavior insofar as the submission of the required information via the monthly schedules is concerned. In particular, the submission of member contact details, which the conduct standard did not prescribe as being mandatory. The lack of member contact details negatively impacts the fund's and administrators' ability to keep members informed of material events that affect their benefits. It is not good enough to only inform the employer or financial advisor, as there is no guarantee that the information would in fact reach the members, specifically where this type of information is directly incriminating upon the participating employer and also affects the relationship where the employer has appointed a financial advisor to assist them. It's my view that by not having made the provision of member contact details mandatory has resulted in challenges for the fund and other funds and administrators, likewise, to adequately be in a position to communicate with and keep members informed in the event of having to notify them of their employer's failure to pay over contributions. In discharging the duty to directly communicate with members, we as a fund rely on notifying members via SMS with a full delivery report of messages delivered being provided to the fund by the appointed service provider. However, a challenge that has been encountered relates to the requirement around having to include an opt-out option in the SMS where members can elect to not receive further communication from the fund and/or funds administrator. Giving consideration to this limitation that we have encountered in the distribution of SMSs, we have, as a backup to member communication, also engaged in sourcing and considering members' email addresses, which has likewise been challenging as the vast majority of our membership in the umbrella fund are blue-collar workers due to the SMME market segment in which many of our participating employers operate. And again, the provision of personal email addresses is not a mandatory provision of the conduct standard. On the challenge of submission of Section 13A reports to the authority, the administrator has been having challenges with the electronic upload functionality of the authority. And to circumvent this, we are therefore submitting our monthly arrear contribution reports in an enhanced format, integrating the requirements from the conduct standard together with the supporting annexures via email. When speaking about the annexures, in respect of Annexure B, which speaks to the proposed course of action implemented to attempt to recover arrear contributions applicable to all affected employers, the board has engaged with the administrator to implement measures to ensure that participating employers are firstly aware of their responsibilities in respect of this conduct standard, as well as direct activities towards the sourcing of complete and accurate information in terms of the minimum information to be contained in the contribution statement that has to be provided by and certified as correct from the participating employers. To this end, our administrator has implemented a process whereby these contribution statements, which are received from our participating employers, are reviewed against the minimum information required, and where participating employers fail to meet this minimum requirements, the administrator attempts to directly engage with these employers to source missing information, as well as reminding participating employers of their responsibilities in respect of the conduct standard. I think it goes without saying, ladies and gentlemen, that this is an extremely resource-intensive exercise when you need to start engaging with hundreds of multiple employers who may have been wanting in the provision of the minimum prescribed information. For arrear contributions, the board, through the fund's administrator, continues to engage directly again with participating employers in attempts to recover the arrear contributions. And during this recovery period, the administrator ensures that members are informed of arrear contributions at 60 days arrears, and every month thereafter until the arrears are either settled or the participating employer is terminated as participant in the fund in terms of the rules of the fund, which is an unfortunate outcome for members, because first and foremost, in everything that we do in the fund, we consider the interest of members. So when we're on the topic of member communication and the limited member contact details that have been provided in this regard, what we are relying on is the 80-20 principle, in that when having reached 20% of members, we are hoping that those members would spread the word to yield an 80% plus reach of members being informed within the specific delinquent participating employer. This is based on challenges identified of members changing SIM cards, having multiple phone numbers, and many other challenges around mobile communication. At best, we believe that as far as possible, we have taken reasonable steps to be in a position to directly communicate with those members whose contact details we have on record. The fund and administrator have been able to integrate and enhance the existing billing and credit control process to the conduct standard for monitoring and reporting. So I think we've been very fortunate that the administrator has always had a embedded billing and credit control process that underpins contribution receipting due to the management of multiple participating employers. However, how has this been approached? How it's been approached is that where a participating employer is in arrears for 30 days, a first credit control letter is issued to such participating employer directly. And the second credit control letter is issued at 60 days together with an SMS sent directly to members whose contact details we have, informing those members of their employer being in arrears and requesting members to contact their employer. I am pleased to report that this has yielded results, as I have had employers contact me about the SMS sent to members, and when considering statistics over the period April to June this year to the same period last year, I have noted a significant decline in the number of delinquent employers in 60 and 90 days, and I'll touch on that a little bit later. It's, however, worthy to note that in our perspective, we are only informing members of arrears at 60 days. So at 30 days, due to the fact that the majority of employers who are in arrears come forward and pay over their contributions and are also very willing to pay LPI as a result of being in arrears. This kind of links onto the note made by Anna-Marie earlier on slip 1 and stitch 1, where employers who are in arrears for short periods do come forward and then pay those over those contributions. And these are the participating employers that I term our frequent offenders, and they are on the reports month after month after month. Some of them have real valid reasons for paying late, while others less so. But as indicated, most do pay those arrear contributions before reaching 60 days in arrears. And I'll provide some statistics to support this statement in a moment. It's for this purpose of managing arrears of multiple employers in the umbrella fund environment that the fund and administrator, in consultation with the FSCA, have therefore debated and defined material contravention as cited in the conduct standard for our purposes as being instances where employers remain in arrears for a period of 60 days or more. For example, I analyzed the 3-month average over the period April to June that I referred to earlier and found that we had 697 PEs in arrears out of 5,246. This accounts for 72% of the 697 being in arrears for 30 days, representing 9.6% of the total employers in the umbrella fund. 18% were in arrears for 60 days, 6% for 90 days, representing 0.8% of our total employers, and then lastly, 4% at 90 days plus, representing 0.5%, and that was 27 participating employers at that point in time. At the 90-day in arrears, the same process is followed by issuing the third credit control letter as well as an SMS to member. As the data illustrates, we have seen a significant reduction in arrear contributions by participating employers at this point in time. So what has led to the drop-off in arrears post these 60 days? During the process where employers are categorized as being in arrears, there is active management by the funds administrator and client servicing team with both employers and financial advisors, informing them of possible solutions to remedy the arrears situation where these employers are facing financial hardships. This is done with the best interest of members in mind so that the employer does not end up being liquidated. Interventions which we encourage range from applying for a payment arrangement to catch up on arrear contributions while paying recurring contributions, while stabilizing the company's income, to having the employer's special rules amended by temporarily suspending contributions, or even considering a reduction in the contribution rate to ease the financial burden on the employer while trying to recover from financial difficulties. The last resort is to, in terms of the fund rules, issue a notice of termination of the employer's participation in the fund due to being in arrears for 90 days plus, and also not having entered into a payment arrangement or amending their special rules. It is at this point where we have also observed that many participating employers suddenly come forward and pay up their arrear contributions. There are, however, those who are just financially unable to pay the contributions. For the last period, I can indicate that we have 12 of those employers who would now be entering into liquidation. Finally, in ensuring that contributions are paid in terms of the employer's special rules, the individual special rules are matched to the recurring contributions at an employer's annual anniversary date or whenever there is a rule amendment. Another area of focus is where a participating employer with arrears terminates their participation in a fund, and this was touched on a little bit earlier, to merely start up a new scheme in another fund within the industry. Within the CSUF environment, where we have 3 umbrella funds, we monitor the new business where we have PEs in liquidation with arrears and then wanting to start up a new fund. If we consider some of the opportunities to be explored, firstly, with not having seen a material change in employers' behavior insofar as the submission of the required information via monthly schedules is concerned, it is suggested that at least one member elected contact detail is made mandatory, which the fund and or administrator can then use to communicate directly with members. Where a participating employer enters into liquidation and upon appointment of the liquidator assumes the role of the board. I have, however, noted recent communication from the authority indicating to the liquidator that the fund is to open a case with SAPS following the liquidator having been unsuccessful to recover all or part of the arrear contributions and LPI from the employer in liquidation. As far as I'm aware, the SAPS case number is required to be indicated or included in the liquidation final accounts. The challenge that was discussed earlier in the webinar this morning is likewise applicable to this, where the opening of SAPS cases relates to the clarification of jurisdiction as to where to open the SAPS case, i.e., do we open the case at the employer's registered business address versus considering jurisdiction of the fund's registered office? And I think this is one area where we need absolute clarification from the authorities to enable us to direct our energies at the right interjunctions, as was also earlier alluded to by the one participant in the webinar, indicating that they spend enormous amounts of time at SAPS trying to open a case just to be referred to having to open a case at the jurisdiction where a participating employer's registered business address is. Likewise, with that comes the additional cost of having to potentially open a SAPS case in a jurisdiction away and far away from a fund's registered office. For our fund, I must state that I do not believe that employers exploit the non-payment of contributions for their own gain, but that it is largely a function of the market and industry in which these employers operate, being very reliant on contracts for income and payments from third parties, which ties the employer's ability to always timelessly honor the payment of contributions. Hence, our high number of regular offenders being from many small participating schemes in the umbrella fund and then paying up prior to them reaching 60 days of arrears. Another very important aspect that I've noted during the implementation of the conduct standard is relationship management. Relationship management is very important, together with proactive engagement with employers at the point where they fall into arrears. So where an administrator picks up that a participating employer has fallen into arrears, it is important that they are made aware of what steps can be considered in situations where they find themselves in financial difficulty and how the fund can assist these employers in such times. This is an absolute win-win solution for both parties and ultimately the members of our fund, rather than leaving the employer in arrears to ultimately be liquidated from the fund where there is no further option. We've really discussed the requirement to report material contraventions to SAPS in length this morning. However, I think it is important to note that clarity needs to be found in respect of the prescribed period, which remains problematic in terms of the fraught inefficiencies within the space of SAPS. SAPS have told me directly that they are not debt collectors and have more important matters to deal with, which goes without saying in our country. There also appears to be a real lack of understanding of the arrear contribution regulatory framework by SAPS officials servicing the public. And I'm sure you will agree that it serves absolutely no purpose by merely filing affidavits with SAPS if you are lucky enough for the officer behind the counter to accept the affidavit to merely tick the box without tangible results of consequence management coming to the fore. The anticipated naming and shaming of funds was also addressed earlier, for which we we provided information to the FSCA as at the end of April 2023. However, this may be deemed to be a probable deterrent or preventative action to encourage such employers to pay over contributions, but could likewise have severe unintended consequences if this is not reported or published timelessly with 100% accurate data of participating employers in arrears. I'm saying this on the back of SMSs sent to members where we notified them of employers being in arrears and members having threatened to burn down the employer's business. So one can just imagine what far-reached consequences it could potentially have when these are published and members become emotional and take course of action that is really not serving the purpose. A suggestion is to consider some level of materiality at which the naming and shaming is undertaken. For instance, employers who remain in arrears for 60 days rather than the 30-day delinquents, as practice has highlighted, but rather to have those who are in 30 days in arrears afforded the opportunity to pay over their contributions with LPI, and that we focus on those who are more likely to become the real problem children of Section 13A. Finally, funds driving member awareness and education in respect of Section 13A and the importance of reminding members to regularly update their contact details with their employers is vital, together with continuous reminding of the participating employers of their duties and obligations imposed upon them in terms of Section 13A are all initiatives that we believe can go a long way in attending to the challenges faced by funds. Thank you very much for the opportunity to have the discussion this morning.
Thank you very much, Mr. Spence, for that insightful presentation and taking us through the fund experience. I see there's a question or a hand from Mr. Silas. Mr. Mothupi?
Yes, I just have a few comments.